Good afternoon, everyone, and welcome to the webinar, Ethical Considerations for Prosecutors in Intimate Partner Violence Cases. My name is Charlie Whitman-Barr, and I'm an Associate Attorney Advisor at Equitas, the Prosecutors' Resource on Violence Against Women, and I will be moderating today's webinar. This presentation will address the ethical considerations outlined in the context of charging decisions, immunity, compulsion of victim testimony, Crawford, and the investigative function of a prosecutor. The presentation will use hypothetical case scenarios to challenge prosecutors to evaluate decision-making in the context of ethical rules and principles. Before we begin the substantive portion of our program today, I will provide a brief overview of our Ilink webinar service. You can listen to this webinar either via computer or conference call. For best use of Ilink, I strongly recommend calling in from a landline to our conference line 530-881-1212, passcode 202-731-738. That number is in the upper left-hand portion of your screen. If you are using a mobile device, please do not use a speaker option, but listen with an earpiece if necessary. All call-in participants have been muted for the duration of today's webinar. Today's webinar is also being recorded for later viewing. If you have any technical issues during today's presentation, you can use the Ilink hand raise indicator, which is located in the toolbar in the top left-hand portion of your screen, above the presenter's photo and to the right of the conference call number. You can also contact Ilink directly at 1-800-799-4510. Throughout today's webinar, our presenter will pose questions to the audience, which you can respond to using the feedback indicator to your left, below the attendee list, or by using the private chat option just below that. We also encourage you to post comments and questions to me, Charlie Whitman-Barr, via private chat, and I will share your questions anonymously with our presenter to be addressed during today's webinar. Today's webinar is hosted by Equitas, the Prosecutors' Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Please note that written materials, including a copy of the PowerPoint presentation and presenter's biography, will be emailed to you after today's presentation. And as I mentioned before, today's webinar is being recorded for later viewing. Equitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Equitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. Equitas staff conduct legal research, provide 24/7 case consultations, host specialized or state-specific training events and webinars, and provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter is Teresa Garvey, Attorney Advisor at Equitas. Prior to joining Equitas, Terry worked for 23 years as an assistant prosecutor in Camden County, New Jersey. For 9 years, she was assigned to the Domestic Violence Unit, and for 5 of those years served as Deputy Section Chief of that unit. Terry works closely with the Victim Witness Advocacy Unit to provide education to the public and to community leaders who come into contact with domestic violence victims. Her jury trial experience includes the prosecution of domestic violence crimes, sexual assault and other violent crimes, drug offenses, property crime, hate crime, and official misconduct. Terry also has extensive appellate experience and has briefed and argued numerous cases in the appellate courts of New Jersey. Teresa Garvey's full biography will be provided to you following today's presentation. I'd now like to turn the floor over to Terry for the substantive portion of the webinar.
Hi, thank you, Charlie. Good afternoon, everyone. I'm Terry Garvey, and as Charlie said, I'm an attorney advisor with Equitas, and we're going to be talking today about ethical considerations in prosecution of domestic violence cases. And we're going to try to learn to identify our legal obligations, also to articulate what those ethical responsibilities will be at each stage in the criminal justice process. Excuse me. Learn to navigate challenges related to prosecutorial discretion, recantation, and disclosure of evidence, which are issues that we all need to deal with, and to approach our decisions and our actions with an eye toward not only doing what we are required to do by our rules of ethics, our rules of professional responsibility, and our standards, and our court decisions, but also to satisfy our obligation in a larger sense of doing justice. So we're going to be looking at it through kind of a large lens rather than drilling down to really technical issues. So we have several sources of authority for our obligation as prosecutors. First of all, of course, there are the rules of professional conduct, which are not unique to prosecutors. They govern the conduct of all attorneys who are admitted to practice in a jurisdiction, although there are usually one or two rules that are specific to prosecutors. We are still required to abide by all of the requirements governing attorneys as a profession. We have the ABA standards for criminal justice, and they have a set of standards that are specific to the prosecution function. And we are not always governed by those in and of themselves. They are advisory in nature. However, often those are cited by state courts in determining what the prosecutor's obligation is. So in your particular jurisdiction, you may have court decisions that say the ABA standards say such and such, and therefore we are going to hold prosecutors to that obligation. So to that extent, they may in fact have an authoritative effect on your practice. We also have the National Prosecution Standards. Those are promulgated by the National District Attorneys Association, and these standards are much more specific. They are much more detailed, and they are much more aspirational in nature. You might, again, have a particular court that, for some reason, focuses on a specific provision, usually to add weight to a decision that they're making. But, again, these standards are not in and of themselves. They don't in and of themselves have any legal effect on what we do. We also are obliged to comply with whatever the case law requires, whatever our courts tell us we must do, and we are responsible for knowing what that case law is and abiding by those provisions. Ignorance of the law is no excuse. Often our local jurisdictions, our local disciplinary boards or bar authority will issue advisory opinions. Usually when someone takes the time to submit a specific question that maybe comes up on a recurring basis, and they will issue an advisory opinion that will clarify what our obligations are in a particular situation. And, of course, finally, we all work in offices, and usually our offices that we work for have specific policies, and those may require us to do things that none of these other authorities require us to do, and we are responsible for knowing those, or else we're likely to get into hot water with our employment. So these are some of the things that are going to tell us what we have to do and how we have to do it. And let's start off with a quote from a case. This is a case when I was an appellate prosecutor. I would often run across in case law or even cite in my briefs where there was an issue of prosecutorial misconduct. If you've never read Berger versus United States, which is a U.S. Supreme Court decision, I suggest that you do so. The prosecutor's behavior in that case was really over the top in terms of the way he conducted himself at trial, the way he questioned witnesses, some of the quote-unquote clever things that he tried to do, and the court was not having any of it and really upgraded that attorney. And by the way, just if the risk of losing your case, having a case reversed, or anything else doesn't motivate you, nobody wants to be the bad example that's cited in some court case. It's very embarrassing and not a pleasant position to be in. But the court in Berger digressed into sort of a colloquy about what is the role of a prosecutor. And what the court said is that a prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty, whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. We're going to come to that theme over and over again. The court went on to say, as such, he is in a peculiar and very definite sense the servant of the law, and the twofold aim of which is that guilt shall not escape nor innocence suffer. And this photograph is actually the Tennessee Bureau of Investigation building. We did a training there recently, and I noted the quote that was on the outside of the building. So I thought that was a nice image to use with this. This is what we're going to keep in the back of our minds anytime we are determining what our ethical obligations are. So when we talk about what's involved in achieving justice, we need to be thinking about that through all the various steps of our prosecution, from deciding what charges to file or to pursue, what reviewing documents such as complaints, criminal complaints, indictments, search warrant applications, when we're engaged in plea negotiations, when we are directing an investigation or answering questions of police officers who are asking for our advice about how to conduct an investigation, when we're actually trying a case in front of a jury or a judge. And finally, after either during pretrial release or post-conviction probation or parole, we want to be involved in achieving justice during that post-conviction or pretrial period by monitoring the situation with the goal at all times, especially in intimate partner violence cases, of making sure that the victim is safe and that the offender is held accountable. Those are our touchstones. Well, there are often other paths to justice or other things that we can do that are going to achieve those goals that we just talked about. We can communicate with our allied partners, and by that I mean advocates, police officers, judges, probation officers, court staff, communicating with all those individuals, corrections personnel, to make sure that we're all on the same page and all working towards the same goals. We can conduct trainings with other prosecutors and with our allied professionals to make sure that, again, that we're all on the same page and that we're all working towards the same goals. We can work to educate our communities. It's kind of ironic. I just noticed that educate is misspelled. That's kind of ironic, and I meant to do that, obviously. But to educate our community about how victims of intimate partner violence can receive assistance, how they can stay safe, how offenders can be held accountable. We can seek restitution for victims. We can direct them to where they can get economic help. We may on occasion have to provide some assistance, not directly necessarily in providing them with civil assistance, but directing them to resources to help with issues like landlord-tenant issues or employment issues when that has been impacted adversely by their involvement in an intimate partner violence type relationship, where the abuser may have damaged the property that they're living in, they may be subject to eviction, or their employer may be unhappy because the abuser is calling constantly or threatening people at the job. We can also participate in our community, coordinated community response teams and work to achieve justice that way. So these are just all things that will help us to achieve justice, which is the goal of all these ethics rules. So this is our hypothetical, and we're going to use this hypothetical throughout the presentation. In our hypothetical, John is charged with aggravated assault. He banged his girlfriend Marie's head against the wall and pushed her down the stairs after he discovered that she had been unfaithful to him. The police were called by a neighbor who heard Marie screaming for help, and John was gone before the police arrived. Marie had a pretty serious head wound that needed 7 stitches to close. She also had cuts and bruises all over her body, and there were photographs taken of all those injuries. She was unable to give a statement to the police, a formal statement at the hospital, due to the potential severity of her injuries. She was under observation and could not be disturbed for a time. However, she was better a little bit the next day, and the police were able to videotape an interview the next day. Now, our first question is, what happens when Marie, and I'm sure anyone who has done domestic violence for 10 minutes has seen this scenario. Marie tells the prosecutor that John never assaulted her and she lied about everything. And we're going to ask you to assume that the prosecutor believes that the incident happened as it was initially reported, and that Marie is recanting not because it didn't happen, but because she's afraid of John and does not want to testify. Does the prosecutor at that point have to drop the case? And we're going to ask you to respond yes or no, or no answer, I guess, if whatever you think the prosecutor needs to do. And here we're talking really about an obligation or an ethical obligation to drop the case, not whether it might be a good idea or whether you think you can win it or not, but whether you're ethically obligated at that point to drop the case.
And Terry, as the answers are coming in, so far we have a resounding no. 100% of the responses have said no. You do not have to drop.
All right. Okay. Great. Well, there, I guess anybody that was on the fence, I just gave you a clue right there. Yeah, the answer, are we finished, or you want to let me know when
we're good,
when we're ready to move on? And we're resoundingly no?
Yes, still resounding no.
Okay, all right. Yeah, here's another question, though. Okay, let's just change the scenario just a little bit. Now, suppose you get this recantation before the charges are filed. Should the prosecutor tell the police to file charges anyway? And again, we're going to ask you to respond to that one.
And the answers are coming in, Terry, pretty much, nope, certainly 100% yes. Oh, we have one so far, a small portion are saying no.
Okay. You can just let me know when we're ready there, because sometimes we have more options, that sometimes the case is easier to sidetrack or sideline before the charges have been filed. Often it's more of a challenge once the charges have been filed. But so we have a minority saying no and the majority saying, I'm sorry, the minority saying no and the majority saying yes. Is that right?
Yep, that's correct. I think we're good to go.
Okay. What we want to think about, first of all, is the rules of professional conduct, which state in Rule 3.8a that the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. We can never know really with certainty what happened in a particular case. We basically are driven by probable cause decisions, and that's what drives the police charging decision as well. The standard for arrest, the standard for prosecution is probable cause. So to the extent we believe that that there is probable cause, often that will guide our decisions. There are other considerations as well that we're going to look at too. The ABA standards just go into a little more detail in addition to the probable cause issue. It also suggests that we consider the absence of sufficient admissible evidence to support a conviction. And this is a situation where when you're talking about admissible evidence, where we may have to think about things like Crawford, whether we're going to be able to, with a recanting victim, whether we have evidence out there that will enable us to go forward with the case with or without the victim's active participation, or even with her active opposition. And we do have, just for the listeners, we do have presentations on Crawford, I believe, on our training site with our webinar recordings. We have a very detailed one on Crawford, and so one of the things that we do need to think about, ideally, is what evidence there is out there that might substitute for a victim's testimony if the victim does not want to participate in the case. And finally, the national prosecution standards bring us back to the bottom line, which is the seeking justice. That we want to, our responsibility includes, but is not limited to, ensuring that the guilty are held accountable, that the innocent are protected from unwarranted harm, which is what they were talking about in the Berger case, and that the rights of all participants, particularly victims of crime, are respected. And the factors, the ABA standard, or I'm sorry, the NDAA standards are pretty detailed, and I've highlighted the factors that are particularly relevant in intimate partner violence cases, which usually do involve violence, or at least the threat of violence or bodily injury. Characteristics of the accused, blameworthiness, so looking at things like criminal record, criminal history, prior acts of abuse, history of protective orders, all that can be relevant. Thinking about the deterrent value, not only in this case, but also to other people in society at large, so that we are sending the message that this is not going to be tolerable behavior. The value to society, as well as the victim, of incapacitating the accused so that he can't continue, he or she cannot continue to victimize others with impunity. The status of the victim, including the victim's age or special vulnerability, and that may have relevance especially in cases involving pregnant victims. We all know that often abuse escalates or begins when a victim becomes pregnant, as well as elder abuse victims. Often intimate partner violence will escalate or begin when people become older. So those victims may have special vulnerability that may be important for us to take into consideration, as well as any other aggravating or mitigating circumstances. And that might include things such as whether the violence occurred in the presence of children who are adversely affected by being exposed to it, whether there are alcohol or drug involved in the case on the part of either the victim or the offender. Those are all things that may go into the mix in making the determination whether we're going to go forward with a case or what charges are appropriate. And we're not obligated either, it's important to keep in mind, always to pursue the most serious charge that the evidence will support. In some cases, it might be appropriate to scale down because of some of these factors to a lower level of offense. And each case has to be judged on its own merits. That's the central message here, is that we can't take a cookie-cutter approach to these cases. We do have to look at all of the factors that are pertinent. Now, this is a question that we're not going to do a poll on, but the question also often arises whether we can give the police advice about filing charges. And this, strictly speaking, is not a question of ethics so much as it is a question of potential liability if you give them the wrong answer or it turns out that the answer caused some kind of harm to someone. Prosecutors normally, for functions that are intimately associated with the judicial phase of the criminal process, we are entitled to absolute immunity. And that's pretty unusual. There aren't many places in the law where someone has absolute immunity. And what that means is if a lawsuit is filed and that is the basis for the allegation or for the civil complaint, basically it will be instantly dismissed. It cannot go forward at all. And that's Imbler versus Packman, a U.S. Supreme Court case. Now, what the question arises, what is intimately associated with the judicial phase? What does that mean? Well, it includes such things as initiating a prosecution, because the prosecution itself is intimately associated with the judicial phase. Presenting the state's case. So anything you say or do in the course of presenting your case in court, that's going to be covered. That's going to be subject to absolute immunity. When we draft legal documents, when we write a brief or draft a criminal complaint or, I'm sorry, let me back up. Maybe not in the case of a criminal complaint, but drafting legal documents, motions, that sort of thing, sentencing memoranda, all of that is would be included within this. Determining whether there is probable cause to go forward with the prosecution, that is covered. Deciding whether to file charges and which charges to file, and presenting information and motions to the court. Does not include such facts or such acts as acting as your own investigator. If you go out and are doing your own investigation and do something wrong, if you're giving advice to the police during an investigation, which is where we started with this question, attesting to the truth of facts in support of an arrest warrant, which means that you're actually the affiant in the case for an arrest warrant or a search warrant, or signing the search warrant affidavit. So those acts are more things typically that law enforcement does. And we do not mean to suggest in any way that you should not be giving the police advice or that you should not do any of these things. Some things, like doing your own investigation, that's often better left to the police. But in terms of doing things like giving advice to the police, that's often part of our job. And we're not suggesting that there's anything wrong with it. The important thing to know is that to the extent we are doing that, we are entitled to the same amount of immunity that a police officer would have doing the same thing. Offering legal advice to police about an unarrested suspect, doing police investigative work, administrative activities. And the rule basically is that when we are acting in the same role as a law enforcement officer, we're entitled to the same level of immunity that they have. And qualified immunity is also called good faith immunity. And it means that as long as you are not intentionally violating the law or intentionally disregarding the law, you're on good ground and you will not be civilly liable. And the standard, the good faith immunity standard or qualified immunity standard, which is the same thing, is that government officials performing discretionary functions generally are shielded from liability for civil damages to the extent that their conduct does not violate a clearly established statutory or constitutional right of which a reasonable person should have known. So you're not responsible for foreseeing changes in the law that happen later. You're only responsible for knowing what the law is as it exists right now and interpreting it in a way that a reasonable person would interpret it. So it still gives you pretty good level of immunity. And again, I don't want to discourage anyone from advising police. We used to have an on-call legal advisor on call 24/7. We took turns covering that duty, and we encouraged the officers to call us in the middle of the night if they had questions about who to charge, how to charge the offense, how to conduct the investigation, and we were happy to do that. And the way we sold it to them was better us be liable than you be liable, because to the extent they've asked us, they've probably showed that they have acted reasonably. But it was a risk we were happy to take because it really improved the quality of our cases when they asked us for legal advice. Question now that our victim has recanted, do we arrest the victim for false reports? And we're going to ask you again to respond yes or no. People often have a strong feeling about that one way or another.
And as a quick reminder, you can use that feedback indicator to the left of the presentation screen to answer the question yes or no. And Terry, as the answers are coming in, we have about 95% saying no with 91% saying no with a small 9% saying yes. And that's where we are with the answers.
Well, this isn't, just to be clear too, this is not a question of whether you can arrest the victim for false reports, but really whether it's a good idea, whether it's in the interest of justice. So what we can do in this situation when we have something like that, even if we aren't sure what really happened, we can think about what those charging factors are in the NDAA prosecution standards. And some of the questions that would be relevant in this kind of situation is, would society really benefit by our prosecuting this person for this situation? How blameworthy is the victim? Is she maybe compelled to act this way because of the abuse she has suffered? And again, and I usually do a disclaimer at the beginning, but we often refer to the abuser or the batterer as he and the victim as she. We certainly recognize that there is same-sex domestic violence. There are women who abuse men, and statistically, the greater number of cases have female victims and male abusers. So that's really just a recognition of that, but it's easier than saying he or she in every sentence. So I don't want to give the impression that we are not being inclusive here. Is there a need to deter this victim? Is she someone who is going to do this habitually, or is she getting something out of it other than maybe trying to save her own life by doing what she feels she must do? Are there mitigating factors? These are all the kinds of factors, charging factors that the NDAA says that we're supposed to be following. And the bottom line really is whether charging the victim is in the interest of justice. And I would suggest that in the vast majority of cases, unless you have a victim who is literally playing games with the system or trying to set someone up, and I have seen the rare case where that happens, there is no benefit to charging a victim with false reports. Remember that you do need probable cause to charge that as well. And the fact, when we know as much as we do about reasons why victims often do not participate, why they do recant, it may not even rise to the level of probable cause, even though she has made the statement that she lied originally. So that's another important consideration. So this is another situation that we often will have happen. The victim is connected with an advocate. The advocate works with her, and after talking with the advocate, Marie tells the prosecutor that the assault, in fact, did happen as she originally reported it, and that the recantation was just because she felt guilty about getting him in trouble. Now, she tearfully begs the prosecutor to please dismiss the case because it will only make things worse for me. How many times have any of you heard that? Does the prosecutor, now that he or she knows the truth about what happened from the victim, according to the victim, does the prosecutor still have to tell the defense about the original recantation, assuming that had not already been disclosed? And again, we'll ask you to respond yes or no.
And Terry, the answers show about 86% saying yes, with 14% saying no. So a little less, obviously, disparate here.
Okay. So the rules of professional conduct require prosecutors to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense, and in connection with sentencing, disclose to the defense and the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order. So in this case, even if it happened within a week's time, even if it happened within an hour's time, because I have spoken with victims, and after a little bit of conversation back and forth, they have changed their story back that quickly. it's still our responsibility to disclose it because it might be the basis for cross-examination at trial. And if we happen to be a witness in the case, it's important for us to offer to stipulate to the fact that we would say that she said that. So we don't unnecessarily become witnesses in the case. But it is important under the rules of professional conduct as well as Brady versus Maryland. We do have an obligation to turn that information over, even if we don't believe it's true. It's still evidence that a jury would be entitled to hear and that the defense would be entitled to present. And we can certainly have the victim explain why she made those changes. There are ways we can deal with it, but that's information that absolutely must be disclosed to the defense. And similar standards under the ABA's criminal justice standard, with the addition that we should not intentionally avoid pursuing evidence because we believe it will damage our case or aid the accused. I think that's important, that we not turn a blind eye if our case is going south on us. We don't have an obligation to conduct the defense's investigation for them, but if we know that the information is out there, we should follow it up because we lose all our credibility. In addition to possibly violating ethical standards, when we do that kind of lazy or self-serving investigation, we really lose all our credibility with the court, with the public, with the defense bar, and our credibility, once it's damaged, it's very hard to get back. Here's another common scenario. After admitting that it really happened, Marie tells the prosecutor, she will say, she's telling the prosecutor the truth, but if she's called to testify and forced to testify, she's going to say that it never happened. Can the prosecutor, we're not thinking right now about should they or not, but can the prosecutor still call Marie as a witness knowing that she's likely to recant on the stand? We're going to ask people to respond yes or no to that as well.
And Terry, the responses say that 88% say yes, with 12% saying no.
Okay. In this situation, it's important to consider how it's worded, the rule is worded in the rules of professional conduct. Lawyers shall not knowingly offer evidence that the lawyer knows to be false. Now, the question really is, or the issue is, when we put a victim who has told us she will recant or that we have reason to believe will recant, when we put that person on the stand, are we really offering that evidence? Aren't we really going to be asking the jury to disbelieve what she's saying and present other evidence to prove our case? So I think as long as we're making it very clear that this is not credible testimony, or we're not asking the jury to consider it as credible testimony, and in fact we're going to be presenting testimony to counter or discount that, I don't think we're violating any ethical obligation. I don't think anyone would ever hold us responsible for that because we're not asking the jury to believe it. It's sort of like drawing the sting, so to speak, asking the question that you know is going to be negative or bad for your case first so that they're not hearing it for the first time from the defense. It's the same principle. We're not asking the jury to believe it. So now, having not much luck with the prosecutor, Marie decides that she needs her own lawyer. And I've had this situation arise many times as well. And Marie calls the first defense attorney who comes to mind, which is the abuser's defense attorney. And she calls him up and she says she wants to hire him to represent her in the criminal case, to keep her off the stand so she doesn't have to testify. I want to plead the fifth. That's usually what they say. She also wants him to have the protection order vacated. What should the defense attorney do in that situation? And we don't have really a poll on this, but we're just going to think about this scenario. And this is really governed by the conflict of interest rules. That the representation of one client, where the representation of one client will be directly adverse to another client, or where there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client or a third person, or by the personal interest of the lawyer. And this is from the Model Rules of Professional Conduct. So when you have a victim, even though she says that her interests are aligned with the abusers, with the defendants, with his other clients, and that they are totally on the same page and want to go forward with the story that she made this up, or that she wasn't responsible for what she said, that may not be in her best interest. So a good attorney, a competent attorney, an ethical attorney would probably counsel and advise her that she may be putting herself in jeopardy by asserting that position. That even apart from any legal consequences, she may be putting herself in physical danger by reuniting with the abuser. And that may be inconsistent with what the abuser wants. Because he wants to put her on the stand and have her say that she lied and it was all my fault, I attacked him. So really, that puts the defense lawyer in a pretty untenable position. And I don't know of any situation where the victim of a case could ethically be represented by the same person who is representing, the same attorney who's representing the person charged with committing an act of abuse against that victim. There is an exception in the model rules for waiver where the lawyer reasonably believes that he will be able to provide competent and diligent representation to each client where it's not prohibited by law and each client gives informed consent confirmed in writing, but also where the representation does not involve the assertion of a claim by one client against another client. And this may not be a legal claim specifically by that client against the other client because it's the state that's undertaking the prosecution. It's nevertheless involving an allegation of wrongdoing that was initiated by one party against the other. So I think in the same litigation or other proceeding before a tribunal. So I think, again, that there's really no ethical way that a defense attorney could represent both parties. And the main reason why this is in here, I know everyone here is probably a prosecutor or is on works with victims or is in law enforcement. So we are not probably any of us defense attorneys. But it's important for us to know because it may be important to call this to the judge's attention if a lawyer does try to pull this off, because I think you can probably have that attorney disqualified from representing at least the victim and possibly at that point from representing the defendant as well. It depends on what stance the judge would take. But it's important that we be alert for that sort of thing and not allow defense attorneys. And most defense attorneys, I don't think would try to do this, but for those who would, I think it's important to be to make sure that that is stopped. So here is another scenario. On the very morning of the trial, you're getting ready to go to court. You're not sure whether your victim is going to show up or what she's going to say, but you're met in the office by your paralegal who tells you that she received a message from Marie over the weekend, and she said she did not want to go to trial and she was leaving town. And when you get to the courthouse, the defense attorney comes up to you and tells you that his client thought it over and has decided to accept the plea offer that you previously made, so there's no need to go to trial. And what do you do in that situation? There's no poll here for that. But the question is really whether you need to disclose that or not. And the criminal justice standards, the ABA standards, say that a prosecutor should not knowingly make false statements or representations as to fact or law in the course of plea discussions with defense counsel or the accused. Here, you basically have an attorney accepting on behalf of his client a plea offer that was previously extended. Nobody really knows what's going to happen in a trial. I don't think I have ever in my entire career had a trial that did not involve some kind of surprise. Somebody says something that you don't expect them to say. Somebody shows up who you didn't think was going to show up. Someone told the truth that you thought was going to lie, or someone lies who you thought was going to tell the truth. So we don't have crystal balls. And it may very well be that in spite of this message that was left, the victim might decide to show up, or the case might get continued, and she might be found. So, but on the other hand, if you have the defense attorney asking a direct question, suppose instead the defense attorney had come into court and said, "Hey, my client tells me that his girlfriend left town, that he got a message from her. Did you find her? Do you know where she is? Is she going to be here?" I don't think at that point you can ethically tell the defense attorney that you know where she is and that she's going to be there, because that would be untruthful, that would be misleading, and I think potentially cause the defendant or the defense counsel to take action that they would not otherwise have engaged in had you been truthful with them. But in terms of affirmatively offering out that information, that's a different story. And again, you also need to think, however, about what your reputation is going to be with the defense bar. I always found it very valuable that people knew that I would be honest and that I did not play games with my cases. Depending on how comfortable you are with that, you might feel that not disclosing that information would cause you to lose credibility with your colleagues on the other side of the bar. So it's really kind of a judgment call. I don't think you're required to provide that information, but as I said, you cannot do anything about your reputation once it's damaged. And if you do develop a reputation as someone who hides evidence or hides information, that can be very hard to undo. So it is a judgment call. I don't think for myself I would probably volunteer that information, but I certainly wouldn't go to any great lengths to hide it if I were asked directly. And in the same vein, the criminal justice standards for the prosecution function and the ABA standards also state that a prosecutor should not imply greater power to influence the disposition of a case than is actually possessed. And again, that really just kind of goes to being truthful and honest. You don't suggest you can make things happen that can't happen, either to the victim or to anyone else, defense counsel, to the judge. With all of this, if you're honest at all times, if you're truthful at all times, you're going to, generally speaking, be on good ethical ground. So our duties and obligations don't stop at the time a case is resolved. After John is found guilty at trial, he's sentenced to a year of probation, and as a condition of his probation, he was ordered to stay away from Marie. Now, Marie calls and invites John to come over to her home. And the police discover that because they get into an argument, and again, a neighbor calls the police, and they find John there, and Marie admits that she invited him over, knowing that Marie invited John over, can the prosecution move to have his probation revoked? And again, that's a yes or no.
And Terry, as the responses are coming in, it looks like 91% say yes, with 9% saying no. The prosecutor cannot move to have the probation revoked.
Okay. Again, I think that this situation boils down to recognizing and being aware and educating ourselves about the dynamics of domestic violence. That we know often that victims do try to reestablish contact. And one of the things that we have to keep in mind during our plea negotiations and when we are preparing for sentencing or conducting our sentencing proceedings is we need to recognize the continuum of balancing victim safety on the one hand and offender accountability on the other hand, because they may not always be consistent. And I think it's important that we be very honest with our victims. When we are going to ask for a probationary sentence and we are asking for a no contact condition, to make it very clear to our victims that if they do want to resume contact, they really have an obligation to contact you or contact the probation officer and see whether that condition can be lifted. Because it's important that we try to impose conditions that are going to be possible for victims to live with so that they aren't put in these situations. But the bottom line is we all know that abusers do, in fact, manipulate. They are very good at being remorseful or expressing remorse, and they will exploit the victim's need to feel loved, to want to reestablish this, a normal relationship, to say that they're going to change. And to the extent that we recognize those things, we may not be putting in conditions that are going to be impossible for the victim to abide by, or putting her in a situation where she's going to be easily exploited or manipulated into inviting the defendant back over. But ultimately, the sentence, the sentence for no contact condition on probation or any protective order is an order on the defendant, and we have to hold them accountable for their actions. So if for some reason they do want to reestablish that contact, they have to do it not on their own. They can't be doing self-help. So we want to make sure that our sentencing conditions address the abuser's manipulative behavior. That may involve getting them into a batterer's intervention program, a good one, where there is ongoing monitoring. It may also involve suggesting to the victim or referring her, because we can't really order her to do anything, and it wouldn't be appropriate if we could, but referring her to resources that can help her to escape the abusive relationship, to be in a situation where she can take care of herself and not be as susceptible to manipulation and being put again in a dangerous situation. So again, that's all part of the doing justice in a particular case. So in this particular situation, there are a number of things we can do. We can talk to probation. We can say we want the violation noted so that there aren't repeat violations, but maybe in a particular situation after we talk to the victim does want to have contact. And maybe it's going to be possible for us to somehow amend the conditions of probation so that the victim is not in a situation where the defendant is going to continue to be violated when she actually wants to have contact. We need to be consulting with the victim to find out what she wants to have happen. this escalated into an argument. Does she want this to be repeated, or take the risk that it will be repeated? What does she want us to do? Not that that is going to govern everything we do. We don't allow victims to control everything, but we certainly should at least follow up and try to find out what it is that they want and see whether there's a way for that to be accomplished. And we need to recognize the dangerousness of arresting victims, because sometimes there will also be situations where an officer with all good intentions will charge the victim as an accomplice to the defendant's violation of probation or something like that. And again, we have to recognize that victims are not doing things like inviting the offender over because they want to undermine justice. They just want to have their normal lives back. And arresting victims is almost always a terrible idea, no matter what the scenario, whether it's a victim who doesn't show up for court, whether it's a victim who lies on behalf of the defendant. It almost always backfires because ultimately it's not in the interest of justice in the vast majority of cases, and it's going to actually inhibit victims from reaching out for help in the future. If this is how they're treated once they're involved in the criminal justice system, then they are opening themselves up again to the same kind of treatment if they call the police again. And it really will result in victims being reluctant to even pick up the phone and call for help when they need it. So we're pretty nearing the end here. Does anyone, before we get to the end here with a couple of inspirational quotes to send us our way, does anyone have any questions or anything they'd like to throw out to ask their fellow colleagues?
If you have any questions or comments, you can private chat them to me now or as we continue to wrap up for the webinar today, but you can private chat those under the chat window. Terry, we did have one question that talks a little bit about examples of manipulative behavior. If you can go into that just a little bit more with the time that we have when you were talking about how that would affect sentencing conditions and what you pursue.
Okay. Well, it's important for us to recognize that offenders do part of the whole scenario with domestic violence, intimate partner violence, is power and control, and manipulation is a very significant element of that. Often we have witness intimidation. We call it witness intimidation, but it's not always a heavy-handed threat. Often it's very subtle actions. It's apologies, it's promises, it's I'm going to change, it's making the victim feel guilty. So it's important for us to talk to the victim at some length and find out a little bit about what the history of the relationship is, what it is that they want to see happen, because it's really their lives. In some cases, an offender is going to be so dangerous, we just have to say no contact regardless of what the victim's wishes are. But often, if we are able to work with the victim and come up with resources to assist the victim will then be more amenable to recognizing that maybe this continued contact is not in her best interest. We can hook them up with counseling. We can hook them up with an ongoing advocacy or treatment or resources that will make them less dependent on the abuser. And obviously, like I said, we can't do that in terms of making her or imposing any conditions on her as part of the offender's sentence. But we can recognize what resources are out there for her in determining what we have to do to protect her. I don't know if that kind of puts it in a little better, more context, or provides a little more context.
That is great. Thanks so much, Terry. And we have one additional comment I did want to share in case you had anything else to add to that, was that Children are often a very significant factor in domestic violence offenders and what the victim looks for as a prosecution and resolution. So I just wanted to share that comment as well.
Okay, and that's certainly very important to keep in mind as well. And I want to thank everybody for your attention. I'm going to just close here with a quote from Justice Robert Jackson. This is from an address delivered at the Second Annual Conference of the United States Attorneys in 1940. The prosecutor has more control over life, liberty, and reputation than any other person in America. Nothing better can come out of this meeting than a rededication to the spirit of fair play and decency that should animate the prosecutor. Your positions are of such independence and importance that while you are being diligent, strict, and vigorous in law enforcement, you can also afford to be just. And although the government technically loses its case, it is really won if justice has been done. So going forward, we want to focus on exercising our discretion, of which we have quite a bit. Exercising that appropriately. If we consult with our supervisors when we're in doubt, we will be protecting ourselves and receiving guidance from someone with more experience. And we want to protect our reputation for fairness because, as I said, you can't really get that back once it's gone. And with that, thank you very much for your attention, everyone, and have a great rest of your evening. I'm already on Friday.
Thank you so much, Terry, for all that great information, and thank you all in attendance for your participation today and for your dedication to increasing victim safety and offender accountability in your communities and across the country. When you exit Ilink, we do encourage you to visit our website at www.equitasresource.org, where you can register for future webinars and training events and review additional information about Equitas. You will be receiving a link to a SurveyMonkey evaluation for today's webinar, along with a copy of the PowerPoint presentation and Teresa's full biography. You can respond to the follow-up email if you're interested in continuing legal education credits. Please do remember also that Equitas is a 24/7 technical assistance provider, and we're available to respond to questions, concerns, and training needs as they relate to the prosecution of violence against women. So on behalf of Equitas, thank you all so much for participating in today's webinar. Thank you.